This hearing is in Re iCap Enterprises, Inc., case number 23-01243. The matters before the court today is a status conference and omnibus hearing. A motion on bidding procedures identified in the case docket as ECF 187. A motion to authorize for appointment of independent directors. That's ECF number 210. Motion to shorten time, 221. On the line, on behalf of the debtors, we have Dakota Pierce.
Good morning, Your Honor.
Julian Guruli.
Good morning, Your Honor.
And Khaled Terasi.
Good morning, Your Honor.
On behalf of the committee, Jason Wax.
Good morning, Your Honor.
Gary Dyer, on behalf of the U.S. trustee.
Good morning, Your Honor.
Vadim Rubenstein, on behalf of Serene Investments Management.
Good morning, Your Honor.
Paul Ressa, on behalf of creditor Sue.
Good morning, Your Honor.
John Ducey, on behalf of Anthony and Sandra Diesel.
Good morning, Your Honor. Happy holidays.
And Jihu Huang, on behalf of Final Life Industrial Corporation.
Good morning, Your Honor.
Alan Benson, on behalf of Hugh Goldsmith and Associates.
Good morning, Your Honor.
Is there anyone else on this call that I did not identify?
Yes, ma'am. My name is Greg Rumsey. I am with Holtquist Homes. I have interest in the stalking horse.
And Madam Clerk, this is Lance Miller, the Chief Restructuring Officer. Thank you.
This hearing is being recorded. Please proceed.
Good afternoon, everyone. I hope you're all doing well today. So we have a couple of motions set for hearing. I wanted to do just a little bit of a cleanup housekeeping regarding our schedule and calendar at the end. But before we do that, I always like to give debtors counsel a chance to provide a general case status update. I did read the status report that was filed yesterday afternoon, which made sense and seemed very straightforward. But Mr. Gooley, if you'd like to preview anything or otherwise address anything else beyond the motions on the docket today, I'd be happy to hear from you.
Thank you, Your Honor. For the record, Julian Gurley of Buckhalter for the debtors. Your Honor, very briefly, in connection with drafting the status report yesterday afternoon and looking at it again this morning, I agree with Your Honor. It's pretty much limited to what we have to be heard today. So I think we could deal with those when we get to them. Your Honor, I would tell you that just generally speaking, in these cases, the debtors, under Mr. Miller's direction and the direction of the debtors' new independent board of directors, which we'll talk about a bit later today, continue to work as expeditiously and efficiently as possible on the main case action items that we outlined for Your Honor at the first day hearing, which of course include the real property analysis and ultimate liquidation, which the SENZA bidding procedures, which is also to be heard today, is sort of the leading edge of, as well as the investigation, Your Honor, that will, I think, provide answers for the court, stakeholders, creditors, and investors in these cases. And as we've described previously, Your Honor, our hope is underpin what will be a largely consensual, is our goal, plan of liquidation in these cases. By way of preview, Your Honor, we didn't mention this in the status report, but in talking internally with our team yesterday afternoon, we anticipate, Your Honor, filing at the end of this week, hopefully tomorrow, an additional ex parte motion for authority to serve out additional 2004 document requests and schedule 2004 depositions. These are aimed at additional parties that were involved in what we've described as the Colpitts Sunset Terrace transaction, which I know we've spoken a bit with Your Honor about, and is one of the sort of more pressing investigation pieces that we're looking into, given the size and sort of late late nature of that transaction relative to the filing of these cases. So those that will be, as I say, Your Honor, by separate ex parte motion, hopefully filed tomorrow, and then we'll get those 2004 requests out to those recipients, assuming Your Honor authorizes the same. Your Honor, in terms of today's schedule, I am planning to handle the independent director motion, and my colleague Khalid Tarazi will handle the bidding procedures. Then that's all I have for updates, Your Honor. Thank you.
Thank you, Mr. Gould. That all makes good sense. So why don't we jump into the motions? So the first matter set for hearing today, the court has previously shortened time, is the debtor's request to approve bid procedures, sale hearing, and related relief for the bidding process relating to the Senza Kenmore property. And the court has reviewed the motion and the timeline. There were not any objections filed. I have a few minor comments in the order, but I'll give anyone who would like to be heard a chance to be heard. But before I do that, Mr. Tarazi, any amplification or comments the debtors would like to provide?
No, thank you, Your Honor. Khalid Tarazi on behalf of the debtors, and there's nothing to add, I think, with the update that we put in the status report related to, creating the record there, and with your brief comments there, no objections were received. So unless Your Honor had any particular questions or comments, and we would take whatever comments you have to the order, of course.
Okay, very good. Thank you, Mr. Tarazi. Would anyone on the phone like to be heard relating to the debtor's request for approval of these bid procedures and the sale process?
Yes, Your Honor. This is Alan Benson. I represent Hugh G. Goldsmith and Associates, one of the lien holders on the property. I apologize. We did not file a response. We don't have any objection to any of the any of the terms of the sale. We would ask that an additional line be added to the order that the mechanics liens be paid out from the cash proceeds at closing. It seems like that's a more expeditious process, since rather than holding on to the cash proceeds and letting everybody fight over that. It just seems like an unnecessary delay.
Thank you, counsel. I understand the issue. I think what the debtors will say is that today I'm just approving the bid procedures, and that the disposition of the sale proceeds should go in a order that'll come later in March, or perhaps earlier if there's no other bidders. But Mr. Crosby, I don't know if you've had a chance to discuss or think about this issue, or if you just prefer to defer it to the sale hearing next year.
We had not, Your Honor. We hadn't heard from counsel, but obviously no criticism there. We just hadn't heard anything to that effect yet, and we were considering that as you refer to them as down the road issues as opposed to today issues. But we can connect on that over the next few weeks, and ideally handle that as part of the sale process as opposed to the bidding procedures process.
Okay. Does that make sense for the attorney who's raising concerns about this? So just so the record's clear, I'm not approving any sale today. All I'm approving is just a timeline and a process for the debtors to conduct a sale process and potentially solicit additional bidders. If necessary, hold an auction for the process. We'll have a future hearing regarding the sale, and all parties' rights are fully reserved with respect to the actual sale. So if there are objections to the price or objections to where the money goes, those are I'm not intending, and I don't believe I'm doing anything today if I grant this motion that would foreclose anyone from raising those issues down the road.
Understood. Thank you, Your Honor.
Okay. Would anyone else on the line like to be heard today regarding this motion? Okay. Well, as I indicated, the timeline certainly seems reasonable and appropriate under the circumstances. It's a fairly typical overbid process and construct that will, if other interested parties are out there, will give them an opportunity to show up. We'll have an auction if necessary, and we'll have a further sale hearing. So the court is prepared to grant the motion and enter this order. Just a couple minor nits, and I need to give you a few dates, and then some additional dates that need to get filled in, just keying off of today's hearing. So on page 2 of the proposed form of order, the beginning of paragraph B on the findings on line 14, there's a singular debtor that should be plural there. Page 5, paragraph 14, I think these are the dates you'll need from me. So why don't we do Monday, March 4th of 2024 as the sale hearing date, and the sale objection deadline can be a week prior to that, so February 26th. Does that work, Mr. Crosby, with the auction timeline? I know sometimes the deadlines can get a little hinky in terms of when the auction's happening and the relative to the objection deadline, but if you think that works for the court.
I believe that works, Your Honor. Yes, thank you.
Okay, so March 4th at 10 o'clock a.m. Will be the sale hearing, and February 26th on or before noon Pacific time will be the deadline to object. Final comment, just a couple more minor nits. Paragraph 17 on page 6, line 23 of the proposed order, there's an it determines at its sole discretion that I think both it should be they determine, drop the S on determines, and then there, since it's multiple debtors. That was it. Anything else relating to that motion or order, Mr. Krause?
That is all. Thank you, Your Honor.
All right, so let's turn next to, we'll first take up the debtor's motion to shorten time to consider the independent director's motion today. I have to say, Ms. Gould, I give the debtors points for enthusiasm and creativity, with the basis for shortening time being so that the debtors will be able to kick off 2024 at full steam. That was, I think, a creative reason for shortening time, but would anyone on the phone like to be heard relating to the debtor's request to shorten time so that the underlying motion can be heard today? Okay. So again, that's an enthusiastic point for enthusiasm in the motion, but given the timing of the filing of the underlying motion relative to today's hearing and what likely will be uncontested request for relief, and the fact that part of the governance issues are being driven by the U.S. trustees' concerns relating to having someone supervise the CRO consistent with the JAX protocol, the court concludes that shortening time so that the underlying motion can be heard today is appropriate. We'll grant the debtor's motion to shorten time. All right, so turning to the underlying motion, the court has reviewed the motion. There were no objections filed. The request to shorten time contemplated that objections may be interposed at today's hearing. I did have just one comment on the order, but Mr. Gooley, why don't I hear from you first if there's anything the debtors would like to amplify, and then if anyone would like to object or otherwise be heard to the motion, they'll have a chance to do so.
Thank you, Your Honor. For the record, Julian Garuli of Buckhalter for the debtors. Your Honor, and thank you for granting our motion to shorten time. We do pride ourselves on being nothing if not enthusiastic. So I think that was sufficient basis, and thank you, Your Honor. Your Honor, I don't have much to add in addition to what we laid out in the motion and Mr. Miller's declaration, which is at docket number 211. Your Honor, as you described, the impetus of this motion was in part driven, at least at the outset, by Mr. Dyer and his office's concerns under the JAX protocol. As you note, as we were discussing those issues with Mr. Dyer, I think it became clear to us and Mr. Miller that I think these cases would really benefit from having an independent board as well, given the list of issues that we're going to be confronting here. I would tell you, Your Honor, that personally I'm very, very pleased, encouraged. We've had very recently our first formal board meeting with the new 2 board members. They are, as you saw in the motion, Your Honor, Craig Barbarosh, who I know Your Honor knows from probably from practice, and if not from practice, from some of his other independent board experience, including the Easterday Ranches case, where he was one of the 3 independent board members. He obviously has a wealth of experience in restructuring and coming from the legal side of the table. In addition, the board is comprised of John Labella, who Your Honor may be familiar with, but he is a partner at J. Alex. He is a CPA, has a wealth of forensic accounting experience and dealings with regulators and the like. I think the sort of combination of those 2 CVs, Your Honor, which were attached to the motion, really are going to be a huge benefit to the debtors in this case, and ultimately to the process that we're trying to execute here. So with that, Your Honor, the debtors would request and submit that there's ample grounds for the relief requested under Code Sections 105A and 363, and request entry of the order. Thank you.
Very good. Thank you, Mr. Cooley. Is there anyone on the phone who opposes the relief requested in the debtor's motion?
Gary Dyer here, Your Honor. I don't oppose the relief. I simply want to thank Mr. Guruli and his team in working collaboratively to get to a resolution that is that works in this particular setting of facts and in this case. And just wanted to make that part of the record for today's hearing. Thank you, Your Honor.
Thank you, Mr. Dyer. I appreciate that, and I certainly understand the governance concerns that the U.S. Trustee's Office raised. The GAS protocol, of course, isn't binding on the courts necessarily, but I understand the reason behind it and makes a lot of sense. And one thing I'll just note in connection with this motion, but kind of more broadly, is I think the debtors have structured the governance here to avoid the problem we had come up midstream in the Easterday cases involving the pre-petition principals attempting to kind of retake over the debtors. I did see that Mr. Christensen's resignation from the board is irrevocable. So unlike the Easterday case, there's not really a mechanism for him to attempt to come back. I know that those issues were ultimately settled in Easterday, but it looks like in this case we've structured things in a way that will be avoiding even the possibility of that fight, which I think probably makes sense. Mr. Wax, would counsel for the creditors committee like to be heard at all relating to this motion?
No, Your Honor, nothing further to add.
Okay. And just to be clear, the committee supports or at least doesn't oppose the motion and is on board with the proposed compensation for the independent directors?
That's correct, Your Honor.
Okay. All right. Well, the court is prepared to go ahead and grant this motion. The court agrees that having Mr. Barbarosh and Mr. Labella involved will be helpful. They will bring experience and expertise involved, and it is a cleaner governance structure to have a board that's supervising Paladin to the extent necessary and providing an additional layer of decision-making. And here, much like the Easter days, I think that debtors are tasked as being the proverbial honest broker and moving the cases forward towards the resolution, and the independent directors will help them do that. The compensation seems generally appropriate, is likely market, and consistent with what the court approved for the independent directors in the Easter Day cases. The committee supportive, and the U.S. Trustee, Office of the U.S. Trustee at least, is not opposing the proposed compensation. My only comment on the order, Mr. Dooley, is on page 3, the second full paragraph. This is the gatekeeping provisions. The paragraph starting, it's further ordered that no person or entity may commence a claim or cause of action of any kind. The final sentence in that paragraph says the court will have sole jurisdiction and power to adjudicate any such claim. So my general philosophy on this is I'm happy preserving jurisdiction, and I may, if we have some scenario in which some sort of claim is being asserted against the independent directors, and I determine it's appropriate for that to go forward so it meets the standard, the gatekeeping standard, I may retain jurisdiction over that lawsuit, but I'm not going to bind myself to that today necessarily. I may, and we're talking about hypotheticals, but I may decide that whatever's at issue, if collateral claims have been asserted, they should be pursued in federal district court or state court somewhere, or who knows, but not necessarily in bankruptcy court. So I would just ask that you strike the word sole from that last paragraph.
Yes, Your Honor. That makes sense. Thank you.
Otherwise, the order looks good. The relief sought is appropriate, and the court will grant the motion and enter an order with that one minor revision. All right. The only other thing I wanted to cover today is just some quick calendaring. We do technically have on calendar for next week an omnibus hearing and status conference on the 27th. We don't have anything set for hearing that day. I did hear there'll be a forthcoming additional Rule 2004 request, which can be granted on an ex parte basis without the need for a hearing. So, Ms. Cooley, do the debtors think we need to keep that hearing next week? And I know it's, the last week of the year, often people like to pick that off. I'd be happy to strike it, but if there's a reason to keep it, we can keep it on the calendar.
Thank you, Your Honor. For the record, Julian Garuli. Your Honor, I don't believe we have a reason to keep that hearing date. We're not anticipating filing anything, which obviously at this point would be on an emergency basis to be heard that date. And I believe, Your Honor, we have an additional status conference on the date on January 9th, pretty soon after the holidays, also in the new year. So I think we could, if it's fine with the court, delete the 22nd.
Okay, that makes sense. The court will strike the December 27th hearing from the calendar. And you're correct, our next scheduled hearing is January 9th of next year at 10:30 a.m. All right, anything further today from the debtors?
No, Your Honor, thank you. I hope Your Honor and your family and the court's staff have a happy holidays and a restful December, closing out the year, and a happy new year.
Thank you, Mr. Cooley. Anything further from anyone else on the phone? All right, well, I appreciate everyone's time today. I also hope everyone has a safe and enjoyable conclusion to 2023. I imagine 2024 will be an interesting year, including in the context of these cases, and I look forward to the debtors now being able to kick off the new year at full steam, consistent with the statement in the motion short in time. Thank you, everyone. Have a great rest of the day. The court will stand in recess until 2 o'clock p.m.
Thank you, Your Honor.